This Honorable Court of Appeals of Tennessee is now in session.
Good morning, Council. Before Mr. Hibner calls the case here, mention one thing to you. We don't anticipate any technology-related problems, but like that. But if we should have any, we'll take a deep breath and pause and work through it. Mr. Hibner, call the case, please.
Park Place Boat Dock Association, Inc. et al. Versus Gary Phillips Construction, LLC et al.
We're here from the appellant.
Thank you. May it please the court, I'm Rick Bearfield, the Washington County Bar. I represent the defendant, Gary Phillips, who is the appellant in this matter. Just briefly, by way of background, Mr. Phillips is seized and possessed of fee simple title in 2.4 acres of land, which lies adjacent to, but is not part of, property which has been developed as Park Place subdivision located in Washington County, Tennessee. The plaintiffs are Park Place Community Association, Inc., a Tennessee nonprofit corporation, and Park Place Boat Dock Association, Inc., also a Tennessee nonprofit corporation. The community association, Park Place Community Association, was formed in 2005. The Boat Dock Association was formed in 2013. The Boat Dock Association and the Community Association, the plaintiffs in this case, purport to be representing the interest of their members as plaintiffs. And it is that fact with which the defendant first takes issue. The defendant filed a motion to dismiss based on lack of standing. The trial court denied that motion to dismiss for lack of standing. However, the plaintiffs nonetheless had the burden at trial of establishing and demonstrating the elements of standing. Neither plaintiff made out the facts or proved facts necessary to make out the required elements to give either of them standing. So initially, I will address the elements of standing, which are the members of these two nonprofit corporations would have to have standing in their own right. And the defendant has no issue with that, presuming that we knew who the members of these communities and boat dock associations were. The second element is that the interest sought to be protected must be germane to the corporation's purpose. And the third element, of course, is that neither the claim asserted nor the relief requested requires the participation of individual members in the lawsuit. I'm going to address each corporate plaintiff separately, and I'm going to start with the Park Place Community Association, which did not prove the elements necessary to establish its right to bring the suit on behalf of its members. The first element that the Park Place Community Association failed on was proof of its purpose. The purpose of Park Place Community Association was never proved at trial. The element is that the lawsuit and the object of the lawsuit must be germane to the corporation's purpose. That mandates and compels the plaintiff to prove what its purpose is. In this case, the charter of the community association, Park Place Community Association, was not introduced into evidence. Now, I will say the list of exhibits provided by the court reporter in the record says that the charter was produced. I think it listed as Exhibit 32, but that's actually not the charter. It's simply the printout from the Secretary of State's office. So the charter was never produced. The charter could have set forth the purposes. We don't know whether it does or not, but it could have set forth the purposes of the entity. If the charter doesn't set forth those purposes, then under the statute, the corporation's purpose would be any lawful purpose. The difficulty posed by the lack of proof in this case is that the statute is only a default if the charter is silent. And it is unknown in this case whether the charter is silent because the charter was not introduced. Without the charter, the community association's purpose can't be known, and it isn't by default any lawful purpose. The bylaws of the Park Place Community Association were appended to the covenants, conditions, and restrictions for the subdivision, which were recorded in the early 2000s. Those bylaws are the bylaws that existed in the early 2000s, but we don't know if they're the same today. And by the way, the bylaws appended to the CC&R do not contain the purpose of the entity.
Counsel, let me interrupt you a second, please, before as your time goes on too far. How is this case, your case, distinguishable from River Plantation Homeowners Association? The appellee raised it in their brief, and I didn't notice that you addressed it in your reply brief. So how is it distinguishable?
It's distinguishable.
It's the standing issue.
The standing issue is distinguishable in that the purpose of the corporation in the case at bar, the purposes of neither corporation were ever proved at trial. And in order for the plaintiffs to have standing, they must prove what their purpose was and that this lawsuit is germane to the purpose. So the failure is in the proof. It's not in the law, it's in the proof. The distinction that might exist at law is that we never get to, because the plaintiff failed to introduce the charter of the community association. The charter of the Boat Dock Association was introduced, but it simply says that its purposes as stated in the bylaws, and the bylaws were not introduced. Not only were the bylaws not introduced, but the secretary of the corporation, who claimed to have the records of the corporation, said she didn't know if the corporation had bylaws. So neither corporation established its ability to stand in the shoes of its members. The other failing in this case is that the plaintiffs failed to identify, or at least the Boat Dock Association failed to identify who its members were. There was no proof of who the present members of the Boat Dock Association are, or whether or not their participation would be required in this lawsuit.
Was there proof that they were boat slip owners?
There were boat slip owners who testified, yes.
So there was proof of that, but you're saying they didn't identify who the particular individuals were by name?
Correct. They identified, the testimony was there are 16 members and 3 or maybe 4 boat slip owners testified. The other 12 or 13 did not testify, were not identified. And in fact, the corporate.
But let me make sure I understand, but you say they were not identified. They were not identified by name, but
Correct.
Were they identified as boat slip owners?
There were no corporate records introduced. There was testimony introduced that if you own a boat slip, you're a member of the association. The failure in that proof is that this record shows that some of those boat slip owners became boat slip owners prior to the formation of the Boat Dock Association in 2013, and that and there's no records at all which indicate that they participate in or joined or have anything to do with the Boat Dock Association. So one witness did testify there are 16 members, but we don't know who there are, and we have no way of cross-examining them. We've briefed that, and I would like to move. I've got about 2 minutes left, and I would like to move to the easement issues. And again, the problem with both easement by implication and easement of necessity is failure of proof. So in this case, of course, to establish an easement by implication, the plaintiffs had to show separation of title and the necessity that it was necessary to show that before the separation, the use was so long continuous as to evidence permanency, and that the easement must be beneficial to the land granted, in this case, granted. All 3 elements are missing. there's no evidence of unity of title between the 2.4 acres, which is owned by my client, the defendant appellant, and Park Place subdivision. There's no evidence in the record of unity of title. There is.
Mr. Bearfield, I'm sorry for interrupting, but am I correct in saying that if your argument is correct, these 16 people who own boat slips, they would have no access to the boat slips, no access to the water at all, because the only way they get that is through the deck and those things that you claim your client owns. Is that correct?
That is correct. Neither they nor anyone else in the world. The object of property ownership is dominion and control, and it is dominion and control to the exclusion of me and the other people who live in Johnson City and the people who live in Park Place. We are not unaware of the situation that was visited on these people by the developer of this subdivision, asking Mr. Phillips to redress the mess that the developer of this subdivision made and that these owners bought into, eyes wide open. It is not proper. It's not proper to ask Mr. Phillips to redress these owners' issues.
Counsel, let me ask you one thing as your time has expired here on your argument in chief. Trial court made credibility findings, correct?
Correct.
And made it against your client, correct?
Correct.
Okay, thank you. You have your time for rebuttal.
Thank you.
We're here from the appellee.
Please the court. My name is Mike Latier. I represent the plaintiffs, appellees in this case, who are the Park Place Homeowners Association and the Park Place Boat Dock Association. This case involves a lakefront subdivision, which had been denied access to the lake by the defendant after the defendant acquired a 2.4 acre underwater tract of land, which abuts the common area. After hearing all the evidence, the trial court made a very detailed, very well-reasoned decision, very detailed findings of fact and conclusions of law, finding that the Homeowners Association and the Boat Dock Association had implied easements, both to the boat dock and to the sun deck. And those implied easements were determined to be both easement by necessity and easement of implication. The defendant has not demonstrated any basis.
Counsel,
I'm sorry.
Did the detailed findings of fact and conclusions of law you said the trial court made, was that in its oral findings or in the order?
Those were in the oral findings that were transcribed. They were not in of course, the judgment was much more succinct.
Did the judgment adopt those findings or incorporate them?
I cannot remember if the judgment did adopt those or not, Your Honor. I wouldn't be able to testify.
Okay, if it didn't, then what do we do with those findings?
Well, the judge reached findings and conclusions.
I understand, but if he didn't adopt them and incorporate them into his judgment, are they part of the judgment?
I think they are part of the judgment. It was the findings and conclusions were held of record, and they were very long, very detailed, and I think they are definitely part of the record.
I understand they're part of the record, but oftentimes we look at whether or not the judgment incorporated these oral findings.
I can't speak to that by memory, Your Honor. I'd have to look at it, but I'm sorry.
I understand. Yeah, don't remember whether I did, but I'm just saying. Okay.
I don't want to tell you wrong on it because I can't remember.
That's fine. Go ahead.
Your Honor, Your Honors, I think it may be helpful to go over some of the undisputed facts in this case that support the findings by the trial court. As Mr. Bearfield said, the Park Place subdivision was planned around Boone Lake. Jerry Howard developed that subdivision. Jerry Howard testified at the trial. The entire concept of the subdivision was based on the homeowners being able to have access to the lake. Now, one thing to clear up, there may be a little bit of confusion. There are approximately 60 homeowners. There are only about 16 boat slip owners. So obviously not all of the homeowners own boat slips, but all of the homeowners have access to the lake through the sun deck and the boat dock.
Excuse me for interrupting, counsel. Could you address specifically the issue of standing and whether there was evidence of the purpose of these associations in this record?
Okay. We submitted the charter of the Boat Dock Association as well as the bylaws of the Homeowners Association. We also had the president and other officers of the Homeowners Association testify. They testified regarding the purpose of the Homeowners Association. They said that they were there representing the interest of the members. They testified that the Homeowners Association is made up of the owners in the subdivision, in the Park Place subdivision. So although we didn't list by name every single homeowner, there was testimony that the homeowners were all members of the Homeowners Association. So essentially the HOA is composed only of homeowners in the Park Place
With
subdivision.
respect to the charter and bylaws and declaration, is that part of the record? You said it was presented or introduced. Was it placed into evidence?
The bylaws of the Homeowners Association was put into evidence. Those bylaws indicate that the Homeowners Association has the authority to represent its members' interests and can essentially act on behalf of its members. And the Boat Dock Association charter was put into record as an exhibit. That also provides that the purpose of the association is to maintain the boat dock and advance the interests of the members. So those documents were put into record, and we also had testimony both of the officers of the Homeowners Association and the officers of the Boat Dock Association, who testified as to essentially the purpose of the association. So the Boat Dock Association was formed for the purpose of maintaining the boat slip, the boat dock and the boat slips. Obviously, the Homeowners Association represents the interest of the members. I would also point out that the Homeowners Association is an owner of property in the subdivision. The HOA owns lot 10, the common area, which abuts the 2.4 acres. And so not only is it composed only of members in the association, but it also owns property in the association. I would direct the court's attention to the Curve Elementary School case that we cited in our brief. And in that case, that dealt with an unincorporated group, I guess you would say. I don't even know if it was as formal as an association, but it was an unincorporated group that represented the parents of a school who were, and that loose association had filed suit on behalf of the parents of the school. And there was a motion to dismiss in that case based on lack of standing. And the court adopting essentially the very loose standards of standing that have been adopted by the Tennessee courts, said that it was clear that the Curve Elementary School Association was representing the interests of its members. So I think we clearly showed in multiple ways the purpose of the associations, both the homeowners and the boat dock association, and that clearly that purpose was germane to the action involved. Trial court found that there was standing in this case. In February of another undisputed fact, in February of 2011, Mr. Howard recorded an amendment to the Park Place CC&Rs where he acknowledged conveyance of the boat slip to the boat slip owners that were identified in that amendment. And this was in addition to the bills of sale and the deeds that were provided by Mr. Howard. After the amendment, the boat slip owners began paying property taxes on the boat slips equivalent to a value of $20,000. The boat slip owners have maintained insurance on their boat slips. The Boat Dock Association has spent thousands of dollars in maintenance of the boat dock. The other thing about the boat dock is that it is attached to the common area by virtue of cables, electrical power, and a walkway. As it relates to the ownership issue, the common title issue, of course, the Wassam case said that as to both easements by implication and easements by necessity, each of them have three elements and they overlap. They're very similar. The elements are very close in terms of what they require. To address the defendant's main point, which is common ownership, he argues that we didn't prove that there was unity of title and then a separation of title. Well, we had Jerry Howard, who was the owner of the two tracts in question. The two tracts in question being the 2.4 acre tract and the common area, lot 10. He deeded both of those tracts. Lot 10 was deeded to the Homeowners Association in 2005, and the 2.4 acre tract was deeded through a bankruptcy in 2014. So Mr. Howard deeded both of those two tracts in question. Importantly, and I think this is important for the court to note, the deed to the defendant, Mr. Phillips, contains the same legal description as the deed to the common area, lot 10. And that deed says that it was part of the same property conveyed to Park Place Properties, which is essentially Mr. Howard. So the deed to the defendant had a description that says it was part of the same property conveyed to Park Place Properties. That's exactly what the description in the deed to lot 10 says.
So
I would also point out,
excuse me for interrupting, is it your client's position that the derivation clause establishes the unity of title?
That is, it establishes it by itself. We also established unity of title through the testimony of Mr. Howard, because Mr. Howard testified that he was the owner of both lots. He testified that Park Place subdivision purchased the property from a Mr. Oliver. He testified that Park Place Properties purchased the subdivision, the lake bed, of course, lot 10 would be included in that. And we introduced as an exhibit, Exhibit 5B, which showed a plat of the original plan of the subdivision. That original plan included certain lots for homeowners to purchase. It included the lot 10 common area. It showed the Boone Lake area. And so that encompassed both lot 10 and the 2.4 acre tract. Mr. Howard testified that Park Place Properties purchased all of that. And Mr. Howard essentially became Park Place Properties. And so through his testimony, as well as through the deeds as well as through the plat, there was more than sufficient evidence to show that there was unity of title. And then, of course, the separation of title occurred when the deed to lot 10 was made out to the homeowners association, and then the 2.4 acres was made to Mr. Phillips. In their supplemental brief, the defendant argued that the derivation clauses were hearsay, and they addressed a 1900 case, a case decided in 1900. That was a land grant case. Secondly, that case did not involve a derivation clause in the deed to the party. In this case, it can't possibly be hearsay because Mr. Phillips acquired the deed that had the same clause in it. So that cannot be hearsay. Essentially, it's clear that the plan of the Park Place subdivision will be thwarted if the easements are not allowed and if defendant were to prevail. In that case, we would have 60 families that would have no access to a lake in a lakefront community. The court found the clear intent, the trial court found the clear intent of the developer of this subdivision was to develop a lakefront community. All the cases that we cited support a finding of easements in this case, as well as standing. And we would request that the court uphold the findings of the trial court. Thank you.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. I want to address this issue about thwarting the purpose of the subdivision. Again, I would reiterate that it is not Mr. Phillips, the defendant's place, to address the failings of Mr. Howard or the situation in which the plaintiff's members presently find themselves. Mr. Howard notably did not make the 2.4 acres part of the subdivision. Mr. Howard did not deed, he never deeded the 2.4 acres to the HOA. In fact, he allowed the TVA to think he was going to deed it to the subdivision in order to get his permits for boat slips. That's the Exhibit 27, Defendant's Exhibit 27. In 2005, Mr. Howard conveyed Lot 10, which is the lot that Mr. Latier was referring to as owned by the HOA. He conveyed Lot 10 to the HOA. And in that deed, which is Plaintiff's Exhibit 5A, in that deed, Mr. Howard reserved for the benefit of the 2.4 acres he owned an easement. He did not grant a reciprocal easement to the HOA across the 2.4 acres that he owned. In 2012, the association asked Mr. Howard to sign an instrument granting the association an easement in the 2.4 acres. He declined. He refused to do it. In 2012, Mr. Howard recorded what purported to be an amendment to the CC&R, even though he had no power to do so at the time. And in that amendment to the CCR, he purported to essentially demonstrate the ownership of the boat slips in certain individuals. His purpose in doing that was so he didn't have to pay taxes on those boat slips because they were taxed to his 2.4 acres. At no time did Mr. Howard ever intend this subdivision to have access to this 2.4 acres by right. He certainly gave them permission as long as he owned it. In fact, that was his testimony at trial. As long as I own it, they had the right to use it. He never intended 2.4 acres to be part of this subdivision or the subdivision to have any enforceable rights in this 2.4 acres. And he demonstrated it. Mr. Latier posited that separation of title occurred when the bankruptcy trustee sold Gary Phillips his lot, his 2.4 acres in 2013. One of the elements of an easement by implication is that the easement prior to separation of title has to be so long and continuous as to indicate permanency. Not only was there no evidence of long and continuous use prior to separation of title, but all the evidence is that Mr. Howard did not intend permanency. He didn't intend for there to be any rights. And I'm sorry for that. And Mr. Phillips is sorry for that. But it's not his place to answer for the foibles of this subdivision developer and the owners with whom that subdivision developer convinced had lake access when they didn't. And none of them checked it. And the TVA thought they were going to, and they thought they were going to, but the truth is they don't. It's not Mr. Phillips' place to give it to them.
Of course, thanks to counsel for both sides. We appreciate your briefs and your oral argument in this. Mr. Hebner, if you would please recess court till our next scheduled case.
This honorable court is now in recess until 11:30 a.m.
Thank you, counsel.